Well, let's debate the government's justice overhaul announced today. And from the foyer of the Commons, we're joined by Marco Mendicino, the Parliamentary Secretary to the Minister of Justice, Michael Cooper, the Deputy Justice Critic for the Opposition Conservatives, and Alistair MacGregor is here for the NDP. Good to see you all, gentlemen.
Good to be here.
Mr. Mendicino, let me start with you. We just heard from a criminal defense lawyer here on our program who says these changes proposed today may actually increase the delays in the justice system, in particular that preliminary inquiries can speed things up in the end, and eliminating them can slow things down. What's your response?
Well, I'm not sure that I agree with that person's view, but look, let me just say that this is a transformative piece of legislation. It represents the culmination of a lot of hard work, extensive consultations. It responds to the Supreme Court of Canada's decision in Jordan, which put the ball back in Parliament's court to change the culture of complacency around the criminal justice system. There are a number of key areas which are actually going to make the justice system fair, more accessible, and provide some protections for victims and Indigenous peoples who are overrepresented in our jails. It's a proud day for Canada. It's a proud day for this government.
All right, Mr. Cooper, what's your response to what the government has unveiled here today?
Well, I think what Bill C-75 represents is another Liberal promise made and another Liberal promise broken, because what we have before us is a 250-page omnibus bill, something the Prime Minister said he would never, ever do. Well, here we are with the second omnibus bill this week. But on to the substance of the bill. We're obviously going to carefully review this massive omnibus bill, but I do think it is a fair question to ask. How can Canadians trust this government to make the justice system more efficient when they can't even manage their own legislative process? This bill actually reintroduces 4 bills that are currently before Parliament. This is the third time the government has introduced legislation to repeal Section 159 of the Criminal Code. That's the section related to anal sex. They introduced Bill C-32 to repeal Section 159. It was such a priority of the government that a year and a half later, it stuck at first reading.
Okay.
They then introduced C-39 a year ago to repeal that section. It stuck at first reading, and now they've introduced another bill stuck at first reading.
Okay, beyond the process, what is it? What's in this bill you don't like?
Well, we're going to carefully study the bill, but I can tell you one concern that we have is that a number of offenses are going to be turned into hybrid offenses, which means that they can be punishable by summary conviction. In other words, 2 years less a day in terms of the sentence. A number of these offenses are very serious offenses, including terrorism-related offenses. So what it appears that the government is trying to do is, under the guise of making the justice system more efficient, is water down sentences for some very serious crimes.
Mr. MacGregor, what do you see here?
Well, with respect to the peremptory parts of the bill, you know, our Justice Critic, Murray Rankin, rose in the House earlier this month and joined with our Indigenous allies to really call for the removal of those. So that's something we do like to see. Like Michael said, you know, it is over 200 pages, so we are still studying it. And I would add to his comments, you know, the glacial pace at which this government is moving with justice reform is something I think Canadians really need to take note of. I think when you want to make a real impact on the justice system, it can't be done just through legislation. We need to see vacancies filled, we need to see resources put into our justice system, but I also want to see some courage. And one of the things the NDP is fighting for is the decriminalization of drugs. I think if we remove that as an offense and stopped criminalizing people who need public health help, that would do some real reform for our overcrowded justice system.
Mr. Mendicino, the point's been made by others, not in the panel here so far, but let me raise it, that the elimination of peremptory challenges, without responding on whether it's the right idea or not, and we've heard from a guest who suggests that that may actually reduce diversity on the juries, because sometimes, you know, you can use those challenges to in fact get through the jury pool to actually get to someone who's more representative of the client you represent. So I suppose there's arguments on both sides, but my question is this, that this measure has been taken in response to the Colton Bushy trial, which is only a few weeks ago, and yet the government's promise to eliminate mandatory minimum sentences has been a promise for over 2+ years now, and we still haven't seen that. Can you explain what appears to some to be a contradiction? You move quickly on something that was in the news and slowly on something you've been promising for 2 years.
The measures in this bill which touch on jury reform are not a response to any single case. And as you may know, and some of your viewers may know, people have a constitutional, a charter right to be tried by an impartial jury of their peers. It's obviously very imperative that we have juries which are representative of the diversity of our country. The reason why I say it's not a response to any one case is that we have seen numerous scholars and now very renowned retired jurists like Frank Iacobucci study the issue very closely, calling for reform, specifically as it relates to the use of peremptory challenges in the criminal justice system. Our bill addresses that. But just on the broader points that have been made by my two friends here.
Well, talk to me about mandatory minimum sentences. Why haven't we seen you move on those yet?
Well, look, the conversation around sentencing reform will continue. As the minister said earlier today in the scrum after the tabling of this legislation, she's working very closely with her provincial and territorial partners. She's also listening very closely to members of the legal profession. And in addition
will we see it before the next election, or are you worried about ad campaigns from your Conservative opponents that'll paint you as soft on crime if you make those changes?
Well, we're not distracted by a lot of the noise that we hear from the rhetoric of the opposition, but we are focused on is the bold reforms. And in fact, one of the bold reforms, which is in Bill C-75, which specifically relates to sentencing reform, is how we're strengthening the powers of a judge to appropriately sentence somebody who has been convicted of intimate partner violence. Now, I would think that that is something that is responsive to what we've heard from victims groups across this country. I supported the minister in a lot of those roundtables. I heard directly from those victims. Hopefully, we'll get the opposition to support those measures as well.
Mr. Cooper, the government promised to undo the mandatory minimum sentences requirements imposed by the former Conservative government, but we haven't seen them yet. Why do you think we haven't seen them yet?
Well, that's maybe one positive aspect of this bill, is it doesn't repeal mandatory sentences. But you know, Peter, there is one thing that this government could do today to deal with the significant backlog in our courts, and that is to appoint judges. And that is something that this minister has repeatedly failed to do. Indeed, under this minister's leadership, we have seen a record number of judicial vacancies. In my province of Alberta, 10 new judicial spots were established a year and a half ago. Do you know how many appointments have been made with respect to those 10 slots won in a year and a half? This while serious criminal cases, including for offenses such as murder, are being thrown out of court. I think what today's bill demonstrates is the failure of this government to move important justice-related bills forward when they have a majority. It's just unbelievable.
Okay, Mr. MacGregor, mandatory minimum sentences. The government promised to do away with those from the previous Conservative government. Still haven't seen them yet. Why not?
It's a growing list of broken promises, I think. When you look at mandatory minimums, we in the NDP firmly believe that the person at the heart of the trial, the judge, who has all the facts before him or her, who understands the situation of both the accused and the other parts of the court system, that the judge is the one who is firmly in control of the facts, and we believe that judicial discretion should be put back in.
The Liberals have said that too.
Yeah, but the other thing about mandatory minimums too is if you have a defendant who's facing a mandatory minimum sentence, they are probably going to choose to defend themselves all the way through, and that can further
that's certainly
clog
what
the
we heard
system.
from. We've heard that from our criminal defense lawyers. Said the same thing, that actually clogs up the system more because there are no options for them, and they'd rather fight it than accept their fate.
And I think you can also raise some legitimate questions as to whether mandatory minimums are actually effective in acting as a deterrent. I have yet to see any concrete evidence to back that fact up.
On that, Mr. Mendicino, we have our criminal defense lawyer guest as well, saying that when you have mandatory minimums, and I think you may believe this, when we have mandatory minimums, you eliminate the ability to plea bargain something else or get a shorter sentence and move to a different court, for instance, and unclog the court system. Do you agree with that?
Well, look, I worked in the criminal justice system for quite a number of years as a federal prosecutor. And look, in some instances, mandatory minimums are appropriate and actually do work. And contrary to what you heard from Alistair, there is some evidence which strongly illustrates that there's a direct correlation between the use of a mandatory minimum penalty regime when it comes to impaired driving offenses and the decline of those offenses in the public. So I wouldn't be so overgeneralizing in the characterization of the use of this. But look, we're going to continue to have this conversation when it comes to sentencing reform. We're going to continue to watch very closely what the courts say. In some cases, they've upheld mandatory minimums. In other cases, they've struck them down. And by and large, when the Supreme Court has struck down mandatory minimums, they were ushered in and shoehorned in by the last Conservative government, which I think discloses a bit of a disregard for the Charter. And just on judicial appointments, let me just say, we had a record year in 2017 of about 100 judicial appointments across the country. We have an open merits-based transparent system when it comes to appointing judges. I'm very proud of the work that the minister has done and will continue to do.
Quick final comments to your two colleagues. Go ahead, Mr. Cooper.
Well, I just wanted to comment. It was interesting, Marco said that mandatory sentences may work with respect to impaired driving offenses. I introduced amendments to Bill C-46 at the Justice Committee to provide for mandatory sentences for the most serious impaired driving offenses, including impaired drivers who kill. It was voted down by the Liberals.
Okay, Mr. MacGregor?
The fear of being caught is a far more effective deterrent than any kind of sentence, and that is what we heard also at the Justice Committee.
Okay, gentlemen, there's lots more. I mean, you're right to the extent that we've just seen all these measures. Now there'll be time to give them a closer look. Have as much rest as you can when you're back in your ridings, doing constituency work over the next couple of weeks, and we'll see you, I'm sure, when you get back. Take care.
Thanks,
Peter.